I would like to introduce our today's speaker, Dr. Advocate Arun Mishra, sir. He's a medical legal consultant and practicing High Court and Honorable Supreme Court lawyer, currently based in Mumbai. The topic today is medical legal awareness in clinical practice. So, Dr. Arun Mishra, sir, is a practicing advocate at Supreme Court, High Court, and medical legal consultant since 20 years now, with experience of more than 16,000 cases, medical legal cases. He has a triple graduation in medicine, microbiology, and law. He's author of 8-volume book on law of medicine. And his goal is to create awareness, unity, and confidence among doctors by bringing them together by voice of doctors. So without further ado, I would like to hand over this talk to Dr. Arun Mishra, sir. Thank you very much for joining.
Thank you, Gaurav, and thanks to all the team. So, Gaurav, as you rightly said, this is an important aspect of medical practice today because day in, day out, I am seeing the increase of litigation in this country, and people are really suffering because there is no expertise they found in the country. And if you ask me, the awareness has gone to that high that even simple medical negligence has seen the litigation in the court of. And yesterday's, if you have seen the judgment passed by Honorable National Commission, which is highlighted in almost every newspaper and naturally goes to every internet media and commonly read by every people, have not only opened the eyes of common people in respect to the medical negligence, but provoked them because they can connect to that particular judgment when you read the judgment or even read the article given on TOI yesterday, when the pediatric surgeon, Dr. Iyer, has been fined for 11 lakh rupees. In 2016 case, if it interest is added, you can just imagine what the scenario. And the observation which was done by the court was really a warning signal to all my doctors because the commonest thing which we need and we see in a practice, which was observed by the Honorable National Commission, that in spite of no negligence or no deficiency found, the very aspect, an important aspect which was commented by the court, that very casual approach of a doctor toward the patient, which cannot be left off, it is real deficiency in service. So if at all you define casual approach of a doctor, it is going to be go with almost every doctor. Because casual approach is the perception of a patient who's or a relative whose patient is admitted. Because doctor comes and takes the round and goes away, hardly give a time, can be a perception of a patient that doctor is not very serious about the patient. That can also be termed as casual approach. Not answering to the question of relative repeatedly asked by multiple relatives, which naturally causes the loss of a time of my doctor because he can explain to one relative, he can explain to two relatives, but not can relate to the same thing of the patient. And if a doctor has refused to answer, that is also termed as casual approach. So casual approach, I don't know what way been defined in future by the court of law, but that was a major ground while giving a compensation, including other ground, which was really a learning to all my participants here. What they said in their judgment, that medical record was not properly maintained, which is a very common aspect in medical practice. Lots of blank space was kept, lots of uh, there's no coherence between the recording and the facts of the case. And moreover, which I repeatedly tell to all my uh, learners in, across the country, in thousands of sessions which I have taken, that your TPR chart and your IPD paper never matches. Because TPR chart is made just half an hour before over by every nurses and the same copy paste reading, whereas the medical IPD paper where 11 o'clock reading of my consultant where vital has been mentioned never matches with the TPR chart is again a ground of, and that has been seen in this matter also, where the advocate, new advocate, they are learned advocate, they compare all this to bring to the court that how the approach of a doctor towards the patient. One more finding which was seen that not in ICU, admitting an emergency or a serious patient, or don't have a facility, then you are trying to treat a patient was again a new ground which got created, which has been debated many times. And observation done by the court in this matter that when there is a work going on nearby or probably in a hospital, some room, I don't know, where there is a dust and there is a definitely pollutants, why pneumonia patient has been admitted to this hospital, which can exaggerate the condition. And other observation where for the surgery doctor has defended because the surgery was needed in that scenario. The defense of a doctor was that the consent of father was not there and father has refused to give a consent. As some astrologer he met, an astrologer has said that this is not a right time to do a surgery. And can you understand such a defense will be accepted in the court? Court said such a flimsy defense you are coming out with. Are you a doctor? Are you going to go with astrologer or you with your knowledge? Ask to all the parties. I ask all the participants. When patient is with you, are you going to go with astrologer or are you going to go with your knowledge in any given scenario situation? And then you abandon the surgery and leave the patient for die or death, knowing that without your action, patient may die and death has happened. So these are been well observed by the court when the matter goes to the court of law, and that become a precedent in this country, my friend. Precedent means if one case decided by the court, all other case goes on the same round in future in the court of. And that is a really deadly proposition today's era where my doctor does not understand the same. And that is the reason why in latest past, huge number of cases has gone against the doctor and precedent got created. My doctor never understand that law is absolute. Law cannot be said to be an abstract science, like a medical science, where the approach of two doctors for same surgery may be a different way. Some can go for lateral, some can go for open surgery. Both are right. For treatment for malaria, one can go for artemether, other can go for chloroquine, third may try for primocin. We don't know. All are right because academic just talked about all these things. So where abstract can be accepted, but in law practice, there's no question of abstract. There's a clear question of absolute. Law says 2 into 2 is 4. Law says pregnant hai ya pregnant nahi hai. That is the ultimate. You cannot play with the law. I'll just understand my participant here with one beautiful example. A physician got a patient with newly diagnosed diabetes. He prescribed them with all other medicine, Dianil tablet 3 times a day. Forgot to write a follow-up, forgot to explain the patient, maybe explained, but patient said, I have not been explained. The wife have continued the medicine in spite of complaint raised by husband about giddiness, drowsiness, that could be a symptom of hypoglycemia. But relative thought that could be because of disease, and she continued the medicine. Ultimately, patient landed in hypoglycemic coma and died. The matter gone to the Honorable Supreme Court, and Honorable Court has observed that this is the duty of doctor because he is a knowledgeable person. Patient is a layman. It is a duty of a doctor to explain all side effects, contraindication, drug interaction, and every aspect of medicine he prescribed to the patient. In absence of the same, doctor is responsible and matters gone against the doctor and become precedent. Law is absolute. I know practically for my doctor it is not a drug in short 1 minute time or 2 minute time or 5 minute time which he gives to the patient. But it is deemed that you need to explain them. If you don't, then no one can leave you. On the absolute ground, multiple judgment I found under the court of law where overdoses, where drug interaction, where contraindication has already been decided by the court. In that domain, doctor is deficient. People are taking advantage of the same. Because drug interaction, definitely going to be deficiency in service. Contraindication, definitely going to be questionable given this condition was there, why this injection was given. this is contraindicated in this and how this injection was given. But truthfully, my friend, majority of time, my personal experience being a doctor and being medical legal consultant across the country, I have seen that majority of time my doctor do take a decision on the basis of his experience rather than theoretically which he had learned. Theory is only for his support system, but practical knowledge is there to save the life because only intention of my doctor while treating a patient is to give the better life to the patient or life to the patient. I remember one case of a corporate hospital where RTA patient got admitted with multiple fracture, multiple consultant involved, specialty involved, cranial surgery was done on the patient. Almost 1.5, 2 month patient remained in the hospital and ultimately went in MOF, multi-organ failure. Due to septicemia, patient was septic shock. My doctor with his experience thought, why not give a best shot to the patient? Very common, very natural. He thought now otherwise patient is going to die. Why not do something which can really, by our attempt, can possibly give the life? So they have prescribed broad spectrum antibiotic, vancomycin injection 3 times a day, 2 gram, 2 gram 3 times a day, which was noted by the houseman on IPD paper. Patient died only on the ground of a single liner, which houseman has mentioned on his document. The doses given by the competent doctor been challenged in court of law on the ground that maximum dose of vancomycin prescribed by FDA is 2 gram a day, whereas 6 gram a day is pushed in the body of patient, and the overdose of vancomycin leaded to nephrotoxicity and neurotoxicity. 2 organ got failed because of that, and patient died. And law says we believe in absolute. When FDA has said something, we need to follow. So when 2 gram is advised, you need to go with the 2 gram. Why 6 gram? Are you getting me? My doctor were only intended to give a life, 1 crore compensation. My friend, try to understand we are in an era where 50% population of this country is below 25 years age group. Below 35 is around 73% population, and all are master in internet. They surf internet like anything. You just see majority of time of people goes on internet, either through mobile or through variable design, and everything get highlighted. Every case get highlighted, and that they immediately forward to all their friends as a social media tycoons. The case decided an anomaly by Nagpur bench, wherein anomalous scan, radiologist could not able to see some deformities, ended with 1.25 crore compensation. And 1.25 is not a small amount. And because of that, today, my experience, around 10 cases of anomalous scan I must have got. Because every people who reads feel that same has happened with me. Symbol cleft plate has gone to anomalous scan cases. Here, everything cannot be seen. Doctors got some limitation in their practices. Probe has got limitation. But now, since because of one judgment, every patient whose bachu come with little deformity are blaming now for anomalous scan. And this is happening with every field. I'm not about radiologist, I'm not about pathologist, I'm talking about every field, my friend. Till the time, only litigation and allegation was there, it was better. But now I have seen the changes in our country where criminal litigation has been the new domain. And is very true also. My patient immediately run to the police for any issues they have got or any allegation they have got on anyone. The first option is the police station. And now police is also interpreting the law the way they want it. The advocates are helping them to interpret the law. And the section has been put on doctors. Earlier, 304A was the only domain where my doctor was booked under negligence when death has happened on table, which says causing a death without intention with negligent act up to 2 years punishment, payable offense. But nowadays, 304 become very, very common. Now, what this 304 says, causing a death without intention, with the knowledge that particular thing can lead to death. The knowledge component in definition which is added turned the section to non-bailable 10 years punishment. Injection given by homeopathic doctor leading to septicemia and death is termed to be a knowledge in a cross-pathy practice. 10 years punishment, 304. Not being allopathic doctor, I am using allopathic method, leading to death. A case of Delhi which I have got, where general surgeon, I am talking about general surgeon, got a patient with a PV bleeding, done the procedure or patient maybe TNC, allegation was of MTP, complication happened, post complication, patient died. My surgeon was booked under 304 with 315, saying that not being a gynecologist, you have crossed over the field of a gynecologist. I don't know how presentation could not be done by the advocate in court that he was a basically MBBS. But only on the ground that not being a gynecologist, cross over the field of a gynecologist comes with a component of a knowledge. 10 years punishment, doctor remained almost for 62 days in a jail when this came to me, and then I have interpreted and guided to take a bail from Supreme Court. Laws are changing, my friend. An ENT surgeon posted a patient for peritonsillar abscess. 2 o'clock, he admitted the patient in the hospital. 4 o'clock, he called the pathology department for the medical report. All investigation report was on normal. Posted a patient in OT at 5 o'clock. Medical mishap happened. Patient ultimately died. The ENT surgeon, the anesthetic has tried their level best to give a life. They called their physician friend, who also accompanied them and tried to save the life of the patient. Died. 7:30, police was given a medical record and a body for the postmortem. Now, the grossest mistake done by my doctor, and which is a very common, I can see everywhere, that investigation report was not handed to the patient because it was with pathology. And it is a routine habit in every hospital, including Nanavati Gaurav, that investigation report is added in a file at late night or next day morning when it comes in the hand of a nurse. So emergency, they forgot to give. And the comment done by the opinion giver, in this case, when there was no investigation report in hand by expert committee, they said either investigation not done or not documented. My doctor were knowing that my fellow doctor is not going to do a surgery without doing a proper investigation. But since report was not there, they mentioned one word, either not documented or not done. 304A was applied on a physician also with ENT anesthetic because another observation was there that when froth was observed, clear indication of pulmonary edema, why diuretic classics given after 45 minutes? It's not that my physician is not given on time, but while writing particular and things would have mismatched. Law is absolute. Physician also got arrested. The public prosecutor has argued for almost 45 minutes in this case, trying to change the section from 304A to 304 claim to make it non-bailable. I got the bail, that is a different issue. But my friend, and I advise to every people, the knowledge component you need to take seriously, because if you don't do a proper investigation prior to the surgery and procedure, you don't know if patient has got blood disease, HB is less, or some other disease. For basic, there was a case I know where tooth extraction was done, simple procedure. In a known case of a diabetic patient leading to septicemia and death, doctor was booked under 304. 10 years punishment, non-bailable offense. But one thing is good in our country, my friend. The law is protecting us. The Honorable Supreme Court's judgment very categorically said that human body is a complex machine. Medical science is a complex science which is beyond imagination of any medical practitioner. Hence, for medical mishap, even in the form of a death, doctor must not be held criminally liable. But rider they have mentioned if due care has been given. Due care means if I came to know about the complication, which law says, then have you acted to give a life? Have you tried to give a life to these patients? If you are successful in doing a recitation or transferring a patient or doing anything, you will not be held responsible, my friend. It's not that my doctor does not do this. My doctor definitely do, but my doctor don't document on a paper. So when they don't document, court of law, it becomes very difficult to prove that I have acted on that or not. So my humble request that when you do a recitation or whatever process, make it point that you document everything. That comes under the due care. Otherwise, expert opinion is needed. Law has so beautifully interpreted the occupational negligence and professional negligence that for doctor, they have given a step ahead and said negligence must be gross or high degree of. So in a criminal court, we have been really protected by the law. But my friend, in civil court, we are absolutely not. Let me very honestly tell that court says every simple medical negligence can go to civil court. That is Consumer Protection Act and under civil law of torts. And I found today, because of the NGOs, because of the extortion, because of the legal extortion fees, because the settlement done by my doctor outside the court to save their reputation has increased the litigation against the doctor. Even frivolous cases are going to the court of law. I'll give it two examples. One case I've got where only on a prescription guy has filed a complaint against the doctor, maybe with the intention of extorting the money. Only on prescription. Now, how on a prescription? Let me tell you, my friend. Normally, you'll find that in every case, 4 drugs we do right. Normally, 4 drugs we write. Averagely, if you ask any doctor, one, they will write antibiotic. Second, they will write anti-inflammatory analgesic. Suppose backache patient, fever patient, whatever patient comes. Third, they write PPI drug. Fourth, they write multivitamins. Average prescription I'm talking about. When there is a 4 drugs are there, I have found a case filed by the claimant in a court of law only on a prescription. And what he has done, I will request you also to do the same, just to open your eyes. He has gone on Google and typed all 4 drugs, which will be prescribed by the doctor. Doctor has not prescribed 4 drugs, but around 12 to 14 drugs, because antibiotic double or triple drug combination, PPI drug double or double drug combination, painkiller could be double or triple drug combination, multivitamin around 6 drug combination. You also go and put all this 14 drug on Google and ask, show me drug interaction. You will shock to see that answer is yes to that. And only on the basis of that, law is absolute, my friend. People are troubling my doctors. I have got a case of your Mumbai where this 18-year regular patient of this doctor, a very family patient, you can say, have approached this doctor for running nose, body ache, fever, earache. Doctors diagnosed that as URTI, upper respiratory infection. Given a treatment. Patient was very happy because third day she called her doctor and blessed the doctor. Fifth day, stopped the medicine. Seventh day, fallen at home. Taken to tertiary care center, were diagnosed as acute myocardial infarction. with all top T, ECGs, everything. Died. Postmortem was done. Reconfirmed the cause of death is acute MI. Now, this relative of the patient wanted to trouble a doctor. He filed 1.5 crore compensation case in National Commission, connecting URTI with acute MI. Can you do that? But Google has done. He went to the Google to find out the answer. The connection between acute MI and URTI. You do also today. He has just typed up, show me the connection between URTI and acute MI. Google has shown one symptom, earache. Earache mimics jaw pain. Jaw pain is a sign of cardiac element. And 7 days before workup was not done, was the ground of filing a complaint. When this case came to me, I was utter surprised to see the case because it was already admitted to court of law. And this 65-year-old doctor of mine who was already retired was in so much pain that whole life we don't have an indemnity policy. I said, whatever I have created a wealth for me, I am going to lose all this. I argued the matter. I won the case. That is a different issue altogether because I could able to convince the court that only on earache, if at all, I would have gone for stress test, 2D echo, angiography, lipid profile. Probably the same patient would have come for unfair trade practice. In a country where economicity plays a vital role, I cannot do a CT scan for giving a paracetamol in headache case. Or I cannot go for every investigation just to give a basic medicine. 10,000 penalty was given, but 2 years of pain which this doctor has suffered, legal fees is lost, is irreversible, my friend. That is irreversible. Today, the same thing is happening in our country. The NGOs are filing a cases. Extortionists are filing a cases. Reason I found that people do file a case because they think that settlement can be easily done. And because of the settlement, my doctor suffers a lot because they do a settlement. I don't know why my doctor does a settlement. But they do settlement. In that case, of course, benefit goes to the patient. And that's the reason why cases are cropping up in the country. With my huge experience, I found that if my doctor does not follow a basic defense mechanism, they are not at all safe in this country. Because the CPA Act 2019 is a complete consumer-friendly act, my friend. Everything got changed under this act. Now, complainant can file a complaint where he reside or work again. Sitting in Mumbai, if you have treated a patient of Tamil Nadu or Orissa or Uttar Pradesh, the patient can go to Uttar Pradesh, Tamil Nadu, Orissa and file a case. So now my doctor have to naturally defend across the country. The new law says upper limit is gone because definition of mental agony, loss of constitution has already been defined under that. And multiple judgments said that the upper level of compensation is gone because human life cannot be compensated with any amount of money. I've got a case of 30 crore for cesarean death. I've got a case of simple intramuscular injection DD2 septicemia and death for 28 crores. 10 crores and above is very common in our country. 5 crores easily accepted by the court of law. And my doctor, if get a notice of 5 crore or 10 crore, just imagine what will happen to my doctor. But this is the commonest thing happening in this country, my friend. Only thing I will advise to all my friends, medical council, we are also getting a lots of cases because tweet to PMO, tweet to health sector, tweet to any department, get diverted to your medical council and case get initiated against the doctor. So we are not as safe in today's era. 5 years down the line, we are going to be UK, USA, where every doctor will have a case against them. Satisfaction level of patient has gone very down when health sector is concerned. COVID has given a negative impact of health sector to the patients and to the authorities also. Because in COVID, the relative of judges, advocates, police officers, and common men got admitted to corporate hospital, paid a huge bill, and that pinch, the pain still they are feeling. And that is impacting definitely directly, indirectly towards the health sector. And doctor has been now labeled as a looter. And that is causing a pain. And then, of course, Robin Hood is going to come to this world. कि अमीरों को लूटो गरीबों को दो and Amir means doctor. And doctors will legally loot over those. It's going to be the truth. I tell you, it's going to be the truth. With my experience, my friend, I'll advise to all my participants who have taken out time to safeguard them. And follow 5 steps. With my experience of 18 years, handling 18,000 cases, are all top lot. You go to newspaper, whichever case comes, it has definitely came to me. My experience says if these are the things have been followed, things will different from my doctor. And the first difference I strongly recommend to every doctor of mine and hospital people of mine to maintain a medical record. Focus on a medical record. Long said about this, but still not been followed. Lots of discrepancies are found. But my friend, only evidence in a court of law is a medical record. No other. And then oral does not have got a value. Written prevails. I'll give 2 examples. There was a case of a cosmetic surgeon who has posted a patient for laser hair removal. 10 sitting was advised. 8th sitting increased the frequency, leading to skin burn. Patient has filed a case against the doctor. Doctor defended with a consent paper to the court, saying that this complication was well explained to me prior to the procedure I went on the patient. He has accepted that, which was treated. Where is the negligence? Court has accepted that defense and exonerated the doctor. Another case, neurosurgeon has posted a patient for lumbar puncture in brain disease. Patient died 4 days later. The complaint done by the complainant to the court only on the basis of causing a pain. Now see how much we have grown. He narrated to court that when this procedure was done, I heard a crying and painful voice of my sister. I ran to the procedure room. I found that 2 people were holding my sister and doctor was doing some procedure on her back, injecting a needle. She was crying with the pain. Causing the pain is deficiency in service. My doctor defended himself, saying that I followed a standard protocol of treatment. There's no question that pain can occur because I have used local anesthesia for the procedure. The same. No, LA for the same. But when medical record was observed, it was utter surprise that nowhere local anesthesia was mentioned on a medical record. Casual approach. We have not written, and court has deemed that LA was not given. On against the doctor. So your medical record, my friend, plays a vital role. Try to understand how important is the medical record. Second difference. I cannot take everything here, but I will definitely advise to learn more how to maintain a medical record. I have taken lots of sessions on that. Only on OPD paper, I have taken 2-3 sessions. Only on consent, I have taken 2-3 sessions. Only on IPD paper, I have taken 2-3 sessions. Because it is vast. But please maintain proper medical. Second and greatest difference in civil medical legal is, my friend, criminally you are protected. But my humble request to every practicing doctor here, please cover yourself with a professional indemnity policy. Because that is a blanket difference to you in civil medical negligence. But I will definitely warn all my senior doctors, if at all they are in the part, who has got already policies of 10 years with them, 5 years from them, 8 years them, please revisit your policy. Because this policy was made in 1991, 1998, 2000. Underwriter of those time have taken consideration. But in 2023, whole scenario is different. That policy is going to waste to you, literally waste to you. Because in 2023, we reached to advanced technologies. We reached to LASIK and laser. We are reached to second opinion online consultation. We are reached to robotic surgery. We have reached to cosmetic growth. Everything need to be covered under policy, otherwise your policy is waste. Customized policy is available. I found it after surrendering my medical degree in 2007 and opting for Bar Council registration. And now practicing advocate in Supreme Court High Court with thousands of advocates across the country working for us. I found that these types of things are needed. I founded my organization with the name doctor's risk medical legal services to cover the risk of the doctor. I don't take a patient's case by default because I know if the moment I start taking a patient case, lots of precedent get decided in court of law. I know every bit of negativity or any loopholes of my doctors. I don't take patient's case. When I founded Doctors Medical Legal Services, I found that only medical legal services will not be sufficed for my doctor. Their peace is very important. Their calmness is very important to help a society at large. And that I found because if they've got a good indemnity policy, they can be company. For customized policy, I could able to convince government insurance company in India and also private insurance company. Thereafter, every company started a customized policy first time in the country. I could able to bring these people to cover every aspect. I'll give an example of what need to be covered. It must be 1:1 policy. Means don't go for 1:4, 1:3 where you save a premium. 1:1 means any number of cases in a year. 10 case, 20 case, unlimited cases till the time amount get exhausted. So if you've got 1 crore policy, 1 case of 1 crore, 10 case of 10 lakh, 20 case of 5 lakh or any number of cases till the time amount got exhausted. It covers out of court settlement because many of the time in indefensible cases, reputation of my doctor become very important and definitely my insurance companies agreed to settle the matter outside the court. It covers complete legal fees because across the country, if you need to appoint advocate, you need to know how much you are going to give from your pocket. But now insurance companies agreed to cover complete legal fees up to 1 crore rupees. That means if your policy is of 1 crore, your legal fees is covered up to 1 crore. So unlimited legal fees covered. So you can appoint the advocate of your choice, which includes your compensation legal fees also. It covers all latest technologies, all advancement, including robotic. It covers all cosmetic domain, including hair transplant and IVF and everything. And the greatest plus point, first time ever in a group policy, not in all the policies, since we have signed a MOU with them, they agreed to us because they are getting crores of premium from us. They agreed to give a cashless policy. Means if 50 lakhs is awarded by the court and doctor does not have a payment in his pocket, he need to suffer. Now here, because of the group policy, court has ordered insurance companies agree to pay directly to the claimant. That is the cashless. Doctor need not worry about this. And all appealing can be done if doctor is not satisfied. So one of the beautiful customized policies available with doctorsrisk.com. You can go on doctorsrisk.com, you find such a policy. Please avail such a policy or wherever you get a policy, but do cover yourself with the indemnity. IRDA ruling says, IRDA ruling means insurance regulatory body say that if you've got existing policy with you and still wanted to have another policy, you can take another policy. Your cover will be doubled. 50 lakhs and 50 lakhs become 1 crore. At any given time, you will be covered for 1 crore. IRDA ruling also says that suppose you got 10-year-old policy with some insurance company and you are switching over to New India or any insurance company, your tenure of 10 years, if the retroactive date is mentioned, will be taken care by new company. So all the 10 years cases will be governed and taken by the new company. So beautiful rulings are there. So you don't lose your tenures, you don't lose your seniority of policies, you don't lose any benefit even if you change your policy. But my request that go with customize the policy, my friend. This is the need of the hour. So doctors risk medical legal services tied up with the New India in a group policy is a great defense to my people. Because individual policy of mediclaim is get reputed, but corporate policy of mediclaim never get reputed. Same happened with the doctor. Individual policy of indemnity they can repudiate. But if you are with a group, they lose crores of premium, they don't repudiate, they will give the claim. So be a wise in such a scenario. And what is the amount? Peanut amount. Because of the group policy, doctors has been offered almost 60% discount, 50% discount on the original rate. Like suppose Gaurav, you have taken a policy of a surgeon, which may be costing 24,000 rupees for you, 1 crore. Same policies are available in amount of 16,000 and 18,000. So the discount which is offered by new insurance company is already offered to the doctor. So you get the best bet. For 5 crore policy, where one person have to pay 1 lakh rupees plus GST, are getting 5 crore policy in just 40,000 rupees or 35,000 rupees is the best bet to all my surgeons who are covering a bigger coverage. So much so discounted. And greatest plus point that this policy comes with the added advantage of medical legal services in that. So third difference I will advise to all my learner here or my participant here, that they must have on fingertips some of medical legal experts number. There are huge number. We also have created around thousands of medical legal consultants through Global Institute who are running a course in medical legal consultant program where I teach them mornings. I was taking a lecture for that. In every aspect of handling the cases in a medical practice, because I know there could be scarcity of medical legal people in the country. I cannot reach to all the doctors. So we are creating a medical legal consultant through Global Institute, and thousands of doctors are become a medical legal consultant as they are passionate and interested in that. And that is where we are trying to safeguard our community at large. So they can go to any of medical consultant, but they should have a number. I'll tell you why. Indemnity policy will come in a picture when case get registered against you. But no doctor wanted to have a case against them. No doctor wanted to, because the moment you got a case against you, it become a public document. And public document can be posted on internet. And the moment someone types your name, your case will come first. And you lose a huge number of patients. That is a great loss to my doctor, the reputation loss. And that's the reason my doctor tried to avoid the litigation. It can only be possible with medical legal expert service. In 18,000 issues I have handled, I don't remember any cases gone to the court of. On right time, right support has helped the doctor to avoid the case. So medical legal service comes with a pre-litigation support, where if at all patient asks for medical record, where you feel that he has argued with you, where you feel that his potent litigant, call your medical legal expert, audit your medical record, make it foolproof, answer in such a way that it does not go to the court of law. Your record is going to speak in court of law, my friend, and you need to make a good record of that. During litigation, suppose you are in OT and some complication happened and death has happened, you got enough time to declare a death. Call your medical legal expert. He has got enough knowledge to help you. Technology platform is there. You exchange your paper. He will look to the legal angle also before you declare a death. Understand from him how to handle a mob, how to handle the scenario situation, how to handle the patrakars and medias. With his experience of handling, he definitely going to guide you. Post litigation, my advocates are very good, my friend. I always say my advocates are good, but only problem with them that they struggle with the medical terminology. They don't know what is neurotoxicity and nephrotoxicity. They are not aware about hypoxia and asphyxia. And there the challenge comes with my advocate. But if you got a medical legal expert with you, or medical legal people with you, you need not have to worry because there's a bridge between you and the court. So drafting can be properly done, documentation can be properly done, appearance can be properly done. So pre-litigation, during litigation, post-litigation can be provided by medical legal services. Not only that, in social era, defamation is very common. And we need to protect us for loss of reputation. I have done in hundreds of cases where I have sent a notice to defamator. Even file a case in a criminal court. We all know very recently a judgment came against Rahul Gandhi ji, where he was convicted for 2 years for defaming. Same section applies to defamator who defames you also. And you can take advantage of all this knowledge from medical legal experts. Send a notice to these people. You will save your huge amount of money because of saving our reputation. Where with one notice, they also get fear and remove the blocks. But you need to act on that angle. Since you don't have a knowledge, have an expert to partner knowledge with you. We call anesthetic because we need an expert in that. We call it a physician because we need an expert there. So you have a medical legal expert, go to them. They are the best people to help you out. Lots of medical legal experts are available in the country. Choose one and go with them for any given scenario situation to help you out. Even they can help you in legal recovery of money by sending a notices. So huge number of benefit you have got when you got medical legal expert on a fingertip. So my advice that indemnity policy and medical legal service combined, you take doctors is offering one where they came with a combination of both, or you can opt for medical legal service separately and indemnity separately, depend upon the amount. But my humble request to all my doctor to invest on themselves. Agoni, I'll tell you, Gaurav, this or Prakash, my Nidhi may be knowing. My experience, I'll tell you, for saving a 10 lakh rupees car, which my doctor buys, they pay 35,000 rupees average for insurance, where 8,000 insurance is also available, first party, third party. But ask yourself which insurance you take. And ask yourself 10 years, have your car get accident where you are opted for insurance benefit? Answer is no. But you pay 35,000. But saving yourself, you don't pay 10,000 rupees per person because of whom the car has come. Where only 10,000 you need to pay, 12,000 you need to pay for 1 crore policy for a year. My doctor don't invest on them because pharma has paralyzed them totally. They don't understand what to do. But now time came. The moment case comes to, I'll tell my experience. The same doctor was not indemnified. Come to me and pay me lakhs of rupees fees because my charges are very heavy in court. But they want to go for the best, so they will come to me. And the same time, they repent. If I would have invested, say, probably whole life, I would have got insured with you. But when case comes, we go to the best and pay huge amount. Don't attract that, my friend. You got good people around the country. Invest on self. Be a wise, take a wise decision. And defense in civil, I know my doctors, I know many doctors, where patient goes for allegation, he takes out the printout of that insurance copy and hand over to the patient by I am insured, go to the court. And this is the truth, and this is going to happen in our country like UK, USA very soon. And this is the time where my doctor need to. So first defense, have a good medical record. Second defense, cover yourself with a professional indemnity policy. Preferably, I'll advise the doctors because New India is one of the best company. Third, cover yourself with the medical legal expert services, whichever company you prefer. Doctors, I am learning. Fourth, upgrade your legal knowledge. Today, because of Gaurav, we got connected. Definitely, you have learned something new. Same way, you need to upgrade your knowledge because it gives the confidence to the people. You will find lots of speakers on the internet, spoken lot. You may find lots of articles on internet. I have spoken on IPDP for almost 12 sessions. You'll find my videos also, maybe on Doctors YouTube, Doctors Risk YouTube channel or wherever. Go and at least invest time there to understand that. That will help you to safeguard yourself with lots of litigation in the future. Upgrade your legal knowledge. Our Global Institute of Values Society is already there, who are creating a medical legal consultant. In turn, you can safeguard yourself and other people also can be best bet to you. You can go on gives.co.in, you'll find such a certification courses. Fifth, and very important, communication. Here, I'm not here to talk about communication with the peers or doctors or other people, but I'm here to talk about communication in the form of training to your paramedical staff. In recent past, majority of cases which I'm getting is because of the mistake done by your IABI, ward by PRO, RMO, or could be your nurses. We need to periodically train them. We need to literally train them in attitude, behavior. We need to train them in empathy and sympathy, including medical record, because they are the 90% time with the patient. Try to understand. Not even 10% is invested by the doctor. Their response to the patient plays a vital role. Patient in a pain and nurse is talking with the boyfriend for hours in a phone can lead to vandalization in the hospital. That's my personal experience. Then patient immediately call the relative and a friend because he's in pain. He wants some, if not medicine, at least moral support. Someone can see, examine. So try to train your people because that is going to reduce the litigation, the reputation of the hospital. And of course, hospital indemnity policy, if any participant of mine is here, the new law has changed in this country, where they presented to the court that in cranial surgery, my doctor get 20,000 rupees out of bill paid made benefit which my consultant gets is 20,000, and amount of benefit which the corporate hospital get is 3,80,000. So accordingly, compensation must be awarded. And this precedent got because of the judgment where consultant was allowed to pay peanut amount and hospital almost 90% plus. So all my hospital owner liabilities are going to be almost 100% to you. Another judgment came, beautiful judgment, that personal services will not be governed under the CPA Act. So doctors who are employed under any corporate hospital are known to be a personal service, like a nurses and ward boy and PRO. I'm not talking about the consultant who are on sharing basis. I'm talking about the consultant who are on salary basis. For them, the responsibility of hospital is 100%. So if at all my hospital owner is there, my humble request that please cover your hospital under professional indemnity policy or a error omission policy, which covers all qualified, unqualified staff, covers all visiting consultant, all the owners, medico, non-medicos, all other benefit which I have narrated for 1:1 and cashless and other things. And it includes owner, CFO, CEO, directors, everyone. So go for hospital indemnity policy because that is the only defense which I personally feel. So my friend, let me sum up three liabilities: criminal liability, you are protected by the law; civil liability in the form of consumer, CORA, and civil tort. Take your indemnity policy, professional indemnity policy, preferably from doctor's risk side, will protect you from civil negligence. Medical counsel, not to worry, have a medical legal expert with you who can help you in any given scenario. Five defenses, maintain a medical record. That is going to be a greatest tool to you to safeguard your. Have a professional indemnity policy and error omission policy for the hospital, preferably doctors.com. Have a medical legal expert on a fingertip. Any medical legal expert, I am one of them. Have a good training module for your paramedical staff and upload your medical knowledge. If all you do this, no one can stop you, my friend. No one can trouble you, and you can be safeguarded in this country. With this, I really thank you all for allowing me to speak. Thank to Dr. Gaurav, Nidhi, of course, Prakash, I can see, and many of the participants who were part and parcel to this particular session. So thank you very much to all the people here. I am open to question answer. If at all anything is there, I'll try to deal with the question to make you.
Thank you. Thank you very much, sir, for these very insightful sessions. I mean, a couple of things that we are actually not doing is, having a medical legal consultant on the tip of our fingers. So I probably will do that. Sir, you know that we started this liver transplant program at Nanavati last year, and we are following a couple of things that you already said, like proper documentation and intention to treat attitude at our department. I mean, we have protocols and checklists because liver transplant is a very super specialized service. I mean, so before we started this program, we have this exercise with my senior colleague and director, Dr. Shrimal, where we have all the protocols ready and QNC by the hospital department. We have specialized consent for our patients. We also have, patients family counseling. Once we see the patients, we always go to the patient family and talk to them and make sure that they sign that we have counsel them after seeing a patient every day. So that these are the couple of things we do at our department, and it's very things that we knew from you. It's a very insightful session. I think we'll open floor for the questions. If anybody has questions, Dr. Mishra will answer your queries and questions. So, sir, we have already one questions. Are electronic health record acceptable or has to be physical?
Abhinav has asked this question, and I'll tell you, Abhinav, it is a good question because it is the need of the hour, because we are proceeding towards the digital health, and digital health is the new domain in this country, and even the NMC new draft MCI old act talked about electronic document. Even the Evidence Act has amended to accept electronic document. But everywhere the writer has been given while making electronic record is that it should be in coherent with IT Act 2000 or amendment done in IT Act 2010. Just to make you understand about one pointer in that, I'm not going to elaborate with IT Act 2000 or Amendment 2010. But only one thing which I really want to make you understand what it means, that there should not be tampering of evidence or modification in electronic agreement need to be possible when you are maintaining a medical record. For the purpose of the same, the law says that it must be from one single IP address. Now, I don't think that one IP address is going to suffice to maintain a medical record, because you got multiple computers, multiple laptops, multiple tabs, where everything is done on entry for various devices. So every device has got separate IP addresses. So that is going to be a big question. But only thing that is, yes, that can be a good proposition. Slowly, court has started accepting that. But the crucial document still need to be in a physical. I'll tell you, crucial document, the consent paper. Because wherever there is a signature, you cannot do a copy-paste signature, which is people commonly known as a digital signature, which is not. Digital signature, if at all, people in a business, they understand with ROC certification is a different digital signature. Simple signature and copy-paste on any paper does not give a blanket support to you. So whenever the question of consent is there, my humble request, or wherever signature part is there, my humble request that follow in physical form and can do the copy. Remaining, if you are doing that is not going to be more consent, can be safeguarded. Avoid tampering of the evidence once it's been entered by whatever mean, through software, whatever, where you can prove to the court that all protection, privacy, confidentiality of the patient is taken. Then in such a record, electronic health record is going to be good for the future, and slowly it is going to be done.
Okay, the second question is, can you please write the name of insurance policy to cover for such litigations?
I'll tell you, multiple companies now started coming out with and claiming to be a big thing, but being a doctor, you need to be very wise while choosing a thing, because everything they claim something and on paper comes something else. So I have a side letter from the insurance company that is a, like, suppose when I have tied up with the New India Insurance Company, I made him to write everything which I have claimed here on a letterhead of their company, so that that letterhead is a piece of a document with my doctor, that these are the things are definitely covered, which is just promised by insurance company, so that insurance company cannot run away with their own letterhead. So if it is a cashless, or it is 1:1, or it is covering a legal fees or covering automotive settlement or whatever. So I will definitely advise my friend, when someone is already done for you, don't struggle. I will advise you, don't go for individual policy, because individual is already reputed, because customer lost by insurance company, just one customer, if you repeat it. Because by taking 5,000 and 7,000, 8,000 rupees, they are not going to give a claim of crore rupees. So don't be a fool in this world. Always go with the two things. One, with the policy; second, with the medical legal expert services. Even if at all policy got repeated, your medical legal expert can file a case against the insurance company to make you good. So have a good combination. So as I said, doctors risk, medical legal services, 18 years working in this country, already have got that reputation of handling thousands of cases and spread across the country. Is a group where crores of premium goes to insurance company. Various associations are tied up and going with them. And New India is definitely a government insurance company who is the best bet, because they're the best payer. Private company definitely work for the more margin. Chances of reputation with the private company is very high, because they know out of 10 only one go to the court of law. So they refuse mediclaim also, they refuse all liability insurance also, but insurance company with government holding, you will find a better people there. I will advise you, go on doctors.com, or you can write me on the legal@doctors.com, or you can Gaurav can give my number 9323446163. You can WhatsApp me, I'll help in that. Go with such a policy which is by New India, which gives in letterhead in writing, which really clear all your doubts, with a policy including medical legal services, so that cases also can be avoided, is the best bet to you. So such a policies can cover every types of litigation, including the cosmetic domain, is a real need of hour, including robotic surgery, including latest technology. So go with such a policy. You will be definitely safeguarded.
Okay, the next question is from Dr. Rajesh. Could you please explain the concept of personal service exempted from CPA?
See, there was a beautiful judgment very recently given by the Honorable Supreme Court. And the policy of individual of indemnity will not be useful for the hospital. The hospital was kept liable and insurance policy was with the doctor. And hospital failed to get a benefit of that. The reason hospital need to have a policy. Second judgment came where the service given by the employee, that is a doctor, many corporate hospital do keep doctor on a salary basis. The corporate hospital now in a trend in the country, they pay huge as a salary to my consultant. So when they are getting a salary, they come under the personal services. Like if at all we appoint Ayabai or we appoint the nurses or a ward boy or at home, if at all we appoint a female for our day-to-day work, they all come under the personal services because that is the personal services opted. Services, if at all I'm taking a share from hospital or some incentive from the hospital for the business which I'm providing or some other relation, if at all, for providing a professional service I'm doing. So that is going to go in professional services. So because of the judgment today, I can confidently say that my people who are working with appointment letter, with other things and all, and their role has been defined at the appointment letter or offer letter, whatever document they have got, they can be safeguarded. Their 100% liability is going to go to the hospital for paying the claim, even for the mistake of that doctor or negligence allegation done on that doctor. But only hitch is that, which I definitely request all my doctor to, in spite of all that, have a policy with you. That if you made alone a policy, party, in some other cases where you suddenly, I'll give an example. Suppose you are at home and people know that this building has got a doctor, and you have been called there and you have just given a help to the neighbor, and the neighbor has filed a case against you for medical negligence. You are not covered, then you will be in trouble. So have your individual policy also, but when it goes with the hospital, you can take that difference in a hospital. Being an employee of the hospital, that liability should be like in government hospital, liability is on a government hospital rather than individual doctor because they're paid for that. So that is what is the personal service.
Okay. So next question is from Dr. Mahato. How are the communications on the WhatsApp considered by the court?
After telemedicine law, my friend, we got protected. Otherwise, it was really tough.
Okay.
Yes, multiple time judgment has said that WhatsApp communication will be termed as a legal communication.
Oh.
That's the reason even notices can be sent on WhatsApp. Reply can be sent on WhatsApp. So somewhere legality of WhatsApp has been accepted by the court of law. It is from the same mobile number, not tempered, but it needs to be proved with the circumstantial because tomorrow probably Gaurav's mobile in my hand and I have posted something on that mobile, which Gaurav is not aware of. So that need to be proved in court of law and depend upon the circumstantial things and all. But I am adding one more part to that about the communication for the treatment. So teleconsultation law has already allowed you to give a treatment on a various modality, including the chat, including the audio, including the video, when there is a follow-up patient. But is not allowed for first-timer patient because first-timer you need to go for video consulting unless you are giving a OTC drug. OTC drug, any modality will do. But if at all you want to go for other group of drug, then my friend, WhatsApp communication on a chat is not going to suffice the safeguard.
So, sir, that means the first time consultations, if you're prescribing not the OTC drug, then you have to see the patient physically.
Not physically, even video consultation is allowed.
Okay.
If it is not possible video or you doctor feel that I cannot get a clues from video, then you can call for physical. But video consultation is law in a country where you can connect across the country any patient on video consultation and you can give a treatment to the patient.
Okay. So next question from one of the member. As a postgraduate, one issue which I faced frequently is that the medical registration with state medical council, every time we move from one college to other. If one is registered in a state medical council, can they practice in other states or it absolutely illegal?
See, I'll tell you, Section 27 of old MCI Act was very clear, which is still holding because NFC has already came, but NMC are still to come out the rules and all. But both the council, because apex body is your Medical Council of India or National Medical Council. So they are already said in multiple, their act also, if you are registered with any state council, you are allowed to practice across the country. But only the question is that the health sector comes under the domain of, in the constitutional domain of concurrent list. Concurrent list means where health law can be made by the state also, health law can be made by center also. But now, because of constitution, even if at all center make the law, state have got all the power to adopt it or not to adopt it. The Clinical Establishment Act, made by the center, has not been adopted by Maharashtra yet, even after 22 years. So, state has got their own power to make a law. And that's the reason in Maharashtra, Ayurvedic doctor and Unani doctor are allowed to do modern medicine of practice because of the state review. So health sector comes under the state domain, and that's the reason if you are practicing in the state, the MMP Act 1961, the Maharashtra Medical Practice 1961, very clearly and categorically said that you need to register with respect to medical council, either Maharashtra Medical Council or Homeopathic Council or Ayurvedic Council or could be Unani Council. So health expects you to get registered with state council for practicing in their state. So that conflict always comes in picture, but you can be defended well on the basis of MCI or NMC Act. But my humble request that if you are going for temporary period, then you need not have to change your place of practice. You can just intimate your medical council, respective medical council state, that I am going to go a week or 2 weeks or once a week or whatever. Have a temporary registration for them. If you are regularly practicing in one state, go and apply and take a state registration for yourself.
Okay. So next question is from Dr. Abhinav Jain. So he's a GI physician. He prescribed neuromodulators for functional GI disease, and these are part of our textbook. So, but patient can perceive this are psychiatric medicines.
Let patient perceive whatever they want. You do not have to worry. Law is very clear. What is in your syllabus, you are allowed. Finish.
Okay.
If it is in your syllabus, you are a master.
Yeah.
So don't worry about the perception of the patient, because patient can perceive anything and everything. Need not, because you can't expect them to be a doctor. So if you know that that is your domain, then no one can stop you. You can be well defended. I'll give an example. I got a case where the cancer surgeon has done a chemotherapy on a patient, and the patient has filed a complaint against the this cancer surgeon, that is onco surgeon, that not being an onco physician, you have crossed over the field of onco surgeon. Like you being a liver transplant surgeon, can you be blocked by giving any prescription for liver disease? Ask yourself, are you going to only allowed to do a surgery, or I can give a conservative treatment also?
Yeah.
Are you getting me? So patient can perceive whatever they want. You can't expect patient to be a doctor. So don't worry about that.
Okay. So next question is from Apurva. In the case you described that court argued with doctor that as a doctor you knew surgery is required, then why didn't you do? But how can doctor perform surgery without consent? A negative consent that in spite explaining patient or relatives are not willing. Does it
For a
have
patient, send to some other hospital, send to government hospital. I'll tell you, my friend, let me talk about the consent detail. Where you feel that for saving a life of patient is mandate, don't wait for the consent.
Okay.
I got a case where aneuploids got the patient in a labor pain, breech presentation. Muslim patient, they refuse the consent because they have got in their mind that doctor are doing a surgery for making a money. She was requesting a patient that if fetal heart sound is definitely deteriorating, there's a high chances that bachu may die, that high chances that patient may die, and we need a consent from you. Please give a consent, otherwise it's going to be a typical situation, very, very troublesome situation. Relative said, मर गई तो चलेगा, लेकिन normal delivery करना है. The Muslim patient.
Okay.
And now tell me what doctor will do. And the same question which Apurva has asked, the same doctor in that conflict could not be able to do a surgery. She tried to refer a patient. Patient relative has said, हम लोग जा रहे हैं, मर गई तो देख लेंगे. And they left the hospital. Now, doctor and patient, and such a situation, what you will do? Are you going to wait for the consent? Knowing that patient is going to die, and if you wait for the consent and patient dies, what will happen? And in that case, same thing has happened where patient would die. So, my friend, when there's a question of life saving, you are absolutely protected by law in the form of consent. One. Second, in such a situation, call on 100 immediately, because 100 is a recorded line of a police officer. The moment you call on that number, time you write the name of the person who picked the call, you write, you are safeguarded because everything is recorded there. Whatever you narrated, within 5 minutes in India, I have seen the roundup police reaches to your place the moment they get a call on control room, because control room immediately called to the local police station. The guy who was on a round on a bike will get an immediately call and he reaches to the spot. Take the police officer's consent, take other guy's consent, or they will help you to transfer patient, but life saving become a priceless. Negative consent is good. I will definitely advise because the law of consent was settled in all elective surgeries or non-emergency services. Where it is going to come in picture, where when you have advice for one surgery, like what law expects from you, one, you need to explain the benefit of the surgery you're going to do with the possible complication, the possible benefit on the first step. Second, possible complication in informed consent. I'm talking about informed consent law. Second is a possible complication. Third is alternative, if at all it is available. And fourth is very, very important is the negative consent, the refusal consent. So when it comes, when you advise the first, like cesarean, and patient wanted to go for vacuum or alternatively is a vacuum of or forceps delivery, that could be alternative. And they are not agreeing to you for the first which you advise and agreeing for alternative. Like you're agreeing, you said that conservative treatment for few days can be feasible, but important is to go for the surgery. And if you're not agreeing to your important the first part, then on a fourth part, you need to take a refusal consent that I'll give you an example to make you understand. This was a beautiful example I can say. This was the case of a cosmetic surgeon where this model came to my plastic surgeon for nose reconstruction. My doctor has examined and said, you have already done multiple surgeries in past. And for me, there's no question I can do because there's no cartilage we able to support. So he advised that I'm going to take a cartilage for ribs to do a surgery. She said, I'm a model, I am in an exposure business. I need to expose myself. Any mark on my chest is going to impact my business. She was a model. Doctor said, no, nothing left with me. But alternatively, when it was advised, he said silicone, doctor said silicone can help, but I cannot assure you that silicone is going to be the permanent solution to you or going to be adopted. She said, no, go by the alternative. Naturally, not knowing about refusal, doctor went away. Then the surgery, patient was absolutely fine. Everything was well accepted in her body. 1 year, 1.5 years later, she again came to this doctor. And she told this doctor that I got an offer in some of the movie or some serial where director wanted my nose to be a little sharper. So please do again. I don't want to lose a role. And just imagine the doctor who has taken high risk
to fix it
and done the procedure and last time, knowing that this is the riskier thing what he had done. How come he do again? This time he refused, but this patient was having a high faith on a doctor, compelled a doctor. And doctor done again on silicone, which is visibly failed. Got an infection, just deformities and everything. And then she troubled the doctor like anything. And in such a scenario of refusal consent or negative consent for your advice, it would have been there. Probably safety would have been more stronger. But in emergency, no negative consent is going to help you.
So now that the new Consumer Protection Act, it allows the complainant to file a complaint anywhere. Like you said, you are
Right.
operating in Delhi, but then the patient may be from Tamil Nadu, so he can
Right.
go and file there.
Right.
So what is the solution? How do we get together so that the doctor or the lawyer from Delhi cannot come down to Chennai to fight a case? So like, is there, should we think in terms of forming a network so that the local people in Chennai or any other place can take care of that?
Option is not left with the doctor because they need to appoint a local advocate. Because I'll tell you what I'm personally experiencing that consumer fora is dominant with the local language. So Chennai, if at all case goes, that is going to be in Tamil language. Rajasthan, if you go, it is pure Hindi. If you go to Maharashtra, it is a pure Maharashtrian. And then we need to have a local advocate there to defend ourselves. So even if at all Delhi advocate goes, and the domain there is a local language, will be tough for the Delhi advocate. Second thing, when law is made by parliament, before that they put it on internet for the suggestion and opinion of impacting people. Doctors are not united, my friend. They cry after act get enacted in the country. But prior to that, every act we get opportunity to put something from our suggestion. And we don't do. We think that president karega and secretary karega and association karega. I'll give a live example of NMC draft which was posted on the internet for public suggestion. If you read that NMC draft, it is notified. I'll tell you, it is going to be painful to my doctor. 11 types of punishment has been made under the new draft by medical council, which was earlier 3. First time ever, NMC is taking charge of compensating in the money, which was our domain of CPA Act. So tomorrow onwards, once it gets notified, we need to fight for the compensation in 2 courts, even in NMC. The draft is already on a public domain. If you don't put our suggestion, how come discussion will happen before this get notified? But we always said, ki, yaar, jaane do na, we don't have a time. You ask me the question कि अब क्या कर सकते हैं, तो बहुत देर हो गई है. अब कुछ नहीं कर सकते क्योंकि सुप्रीम कोर्ट को भी एक्ट फॉलो करना है.
Agree.
Yeah, I think that will encourage more of us doctors like us to probably do law and then get into the
Please do.
legal profession along with you. My next question is like when you take a policy from an insurance company as a group policy or something, are we obliged to go with the lawyer suggested by that policy by that insurance
Not
company?
necessarily. I'll tell you about this policy which doctors have tried with India. I could able to take them from writing that advocate can be appointed by doctor independently individually also, not only an insurance company. Because I know that insurance company lawyers are paid very peanut amount, and they are all the new guys, and they are absolutely came with all influences to insurance company, and that cannot be just defended to my doctor. I was knowing that because then again my doctor is important to me. So doctor has got confidence. Suppose doctor has got confidence on me, and my fees is very heavy. How come he engage if insurance company don't allow them? So I made that insurance company should allow my doctor with a policy of appointing any advocate of their choice wherever he feel, and the amount should be unlimited, means up to the policy amount. So if you win the case, you get a benefit that all legal fees is compensated, and if you lose the case, the legal fees with compensation is going to be in a part. So 1 crore, 2 crore policy will cover everything. Don't worry about that. Thank you.
Thank you.